All right, Mr. Gibson, why don't you come up? Mr. Martin, why don't you also come up and have a seat? Mr. Barnett will be with you in a few minutes. Good morning. Are you Devon Allen Martin?
Yes.
This is file number 251308 FD. This started out in the original complaint as a felony. FD is a felony designation. Charged with operating with a high blood alcohol level, operating with an incapacitating injury. Let's look at the original charging document. Thank you. All right, the original complaint alleged that on July 6th of 2025, in this case, which is 251308 FD, People versus Devon Martin, the defendant was charged with operating while intoxicated, causing a serious injury, operating with a high blood alcohol level, and reckless driving. $1,097.42. A floor jack, jumper cables, prescription sunglasses, loss of PTO hours, $2,710.72. Work done to make AC and car work shortly before the accident. Mr. Gibson objects to paying for a repair that preceded the accident and the tires that the victim did not get the full benefit of. So I'm not sure how that shakes out, but the request was for $4,097.42. If I'd had this information at the time of the sentence, I would have dealt with it then, or hopefully it would have maybe been negotiated as part of the plea, but we didn't have that. So the defendant objects. Prosecutor is now requesting restitution of $4,097.42. And I can't just wave my magic wand and make that happen. So we set it for with a lot of money to her. It's ruined. The insurance company pays $1,500 for it. And to replace it would be $7,000 to $10,000. It's a question that comes up all over the state all the time. In this case, I don't know what the vehicle was, how much it was paid for. Now, some of the things are easy to determine. Things that were lost that were not recovered. The jack, jumper cables, prescription sunglasses. I never had anybody ask for the cost of a tire iron before. Work done to make the car before the accident, $559.59 and $424. So there's a lot of money that she's asking for something that presumably would have been part of the settlement on the car. $559.59 plus $424.84 is $984.43 for tires and AC. I didn't see that one coming. The other one is PTO hours, 2,710.
Your Honor, I can tell you that the testimony regarding the PTO hours will be the victim's father. It's my understanding that he had to cash out his PTO hours in order to have enough money, along with adding in the insurance recovery, in order to purchase another vehicle for the victim to have to get back and forth to work, the grocery store, and to do her daily living. They just did not have those funds available without him doing so. So that will, of course, be a decision of the court with respect to that. I know the victims is absolutely recoverable. There will be testimony from her
Yeah,
about the
the
hours.
victims are. I'm not
Yeah.
sure if her fathers are.
There'll be testimony from her loss of income as well as how it affected her work.
All right. Well, let's get started. This is gonna take us a while here.
Call.
We didn't, I guess I would say that I don't have any information on any of the injuries that were sustained, because I guess that's what where I see the request for restitution, but we never got any information about the cause, like in a sense, what injury was suffered from the accident that's made it where the person couldn't work, I guess.
The medical records were all provided in the discovery of the underlying case, Your Honor. Mr. Gibson has had those for quite some time. The victim was taken to the hospital.
Yes. There's no hospital costs or anything in here.
Correct.
All right.
It's my understanding those were covered by medical and or vehicle insurance.
I guess I apologize. We do have medical records. I guess what I'm saying is that I didn't know what the.
Well, I'm just
injury was.
frustrated. I wish this had been negotiated as part of the plea agreement. He got a sweet benefit of having the matter reduced from a felony to a misdemeanor. And it could have been conditioned on agreeing upon the restitution amount. So we have a half an hour scheduled for about a 3-hour hearing. And so we also have Mr. George. Is that the only one you have this morning? Let's table this for a moment. Let's finish Mr. George's sentence. Injury, the defendant's blood alcohol was 0.24. He pled to a charge of operating with a high blood alcohol level, and the court was unable to determine restitution at the time of the sentence. Still looking for the judgment, which Priscilla sent me, but I know it's in here. At any rate,
She's right. Autumn's office.
as I indicated, about a month after the sentence, we received the request for restitution, and then it was an amended one. And I had reserved on the issue of restitution. To pick up where we left off, a defendant requested $4,097.42. $984 of that were for some work that was done to the car before the accident and some tires. And then some items that were missing, a floor jack, jumper cables, and prescription sunglasses. Tire iron would, I guess, be part of the car. At any rate, Ms. Campfield, what's our position here?
Your Honor, after some further conversations with counsel, it's my understanding that we'll be able to limit the testimony to matters in dispute, but at this time, the defendant would stipulate to restitution for the floor jack of $69.95, the jumper cables of $31.78, the prescription sunglasses for $273, and the tire iron for $27.54. So that's a total of $402.27. And then we'll have to present testimony as to the other expenses.
All right. Are you prepared to do that?
Of course.
Mr. Gibson, you agree, and Mr. Martin, you agree to restitution on those items?
Yes, Your Honor.
All right, and the defendant did indicate. All right, let's proceed.
Thank you, Your Honor. We'll call Ms. Kayla Shockley to the stand.
Please come forward if you would. Come right up here in the witness box. I'm sorry, we didn't give you very good instructions. Oh, wait a minute. Instruct people how to bring their witness from there to here, and we kind of got off track here. Would you please raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
I do.
All right, would you have a seat and state and spell your name for me?
I am Michaela Shockley. You said spell.
Go ahead,
You said spell.
spell it.
It's spelled MICHAELASHOCKLEY.
Thank you. Good morning, Ms. Shockley. I'm going to take you and back to July 5th of 2025, ma'am. Do you recall that day?
I do.
In the evening time at approximately what would be 11:30-ish, were you driving your vehicle?
I was.
Where were you driving your vehicle?
I was driving home after work.
On what road, ma'am?
US 131.
And was that within St. Joseph County, ma'am?
It was.
And as you were driving home from work, did something unusual happen?
It did.
Were you involved in a motor vehicle accident?
I was.
What was the vehicle you were driving at that time?
A 2013 Model 4 Prius.
What was the color?
Navy blue.
Can you tell me what special things a Model 4 has in it that maybe some other Prius models do not?
It has a backup camera. It has a navigation system. And hands-free.
Enhanced braking, you said?
Hands-free mode.
Oh, hands-free, thank you. All right. And as you were driving home that night on July 5th of last year after the accident, was the vehicle operable?
It was not.
Would you recollect how it looked after the accident if you saw photographs of same?
I would.
May I approach, Your Honor?
Yes,
I'm going to show you People's Proposed Exhibit 1, and for the record, all the People's Exhibits have been shown to the defense. Do you recognize that photograph, ma'am?
I do.
Is that your vehicle?
It is.
Is that subsequent to the accident that you were involved in?
It is.
Is that the accident that the defendant was convicted for drunk driving for?
It is.
Right. And I'm going to show you People's Proposed Exhibit 2. First of all, Exhibit 1, can you tell me which portion of the vehicle that shows?
Yes. That is my trunk from where he impacted.
And Exhibit 2, do you recognize that, ma'am?
I do.
What is that a picture of?
That is the left-hand side, the driver's side of my car.
All right. Were you seat belted at the time of this accident?
I was.
And let me ask you, when you were subsequently removed from the vehicle, were you able to get out of the vehicle on your own?
No.
When you were removed by medical personnel, were you able to see the exterior of the vehicle?
No, because I was very dizzy from hitting my head.
All right. Did you subsequently see your vehicle as depicted in the conditions in proposed exhibits 1 and 2?
I did.
Okay. Do those accurately depict how it looked after the accident?
It does.
Okay, move for admission of exhibits 1 and 2, Your Honor.
any objection?
No objection.
1 and 2 may be received.
May I ask you, Ms. Shockley, were your airbags deployed in the Prius when you were struck?
Yes.
Can you tell me if there was just one impact by the defendant or more than that?
It felt like two.
Do you recall, and I know that you said you were dizzy, did you strike your head?
I did.
And did you have medical treatment after the accident?
I did.
What type of medical treatment did you have?
I had a CT scan due to the fact that I have a spinal fusion from a previous accident in 2018 that left me with missing intestines as well. And so I'm a priority CT scan for my spinal fusion if I'm involved in a serious accident. And I also received pain medication due to the severity of my sprained shoulder and the pain from my head.
Okay, let's go over your injuries. You said you had a sprained shoulder.
Yes.
Did you have to
Just
have
a
it?
minute. These are all good arguments about why this matter should not have been reduced from a felony to a misdemeanor, but
When all was said and done with the insurance, well, who's your insurance company?
At that time, it was Pioneer Mutual.
What type of insurance did you have on the vehicle?
Full coverage.
So comprehensive as well as PLPD?
no, that's not full coverage. Comprehensive and PLPD is different than full coverage. So you had full coverage on the vehicle.
Okay,
Good for you.
thank you, Judge. Now, when you submitted the claim for your daughter Michaela's accident, did Pioneer pay you out on the vehicle?
Yes,
Did they choose to total the vehicle?
yes.
What was the total payment that you received?
I believe it was 3,900.
When was that paid to you?
It was paid towards the end of July.
Now, there were some questions that we asked Ms. Shockley regarding wage loss reimbursement. Do you recollect any claim being made for her wage loss to the insurance company Pioneer?
I don't recall it, but I think she's right. I think they did give her like a $300 check or something like that.
Okay.
I think they covered like 2 days. Three days.
So of the 5 days that were lost, you believe insurance only covered 3 of them? And we'd already asked some of this to Ms. Shockley, but the items that are being agreed to by the defendant, the tire iron, the jack, things of that nature, did insurance give you any compensation
No.
towards those items?
No. They didn't cover any of the contents of the car.
All right, now, obviously $3,900 is a lot less than the Blue Book values you stated of $14,000 to $15,900, correct?
Yes.
Did you have to get another vehicle for Ms. Shockley to be able to drive to and from work and in her daily living?
Yes.
Do you recollect what vehicle you purchased to replace the Prius that was damaged by the defendant and totaled?
A 2013 Prius Model 2.
So the same year, it was still a Prius, but it was a Model 2.
Correct.
So you'd previously had a Model 4.
Right.
How is the Model 2 different?
No backup camera, no navigation system. It's just above the base model.
Okay. Does it have any hands-free operation?
It does have the hands-free, but it's a different type of hands-free
Okay.
than what's in the Model 4. It's different brand.
So if I'm understanding your description correctly, you replaced the vehicle with something that was a lesser model than what she had been driving on the date of the accident.
With more miles on it.
Okay, and actually for the defendant, because this could have been much worse and she could have been.
Stop. As you may know, I have a sore point for under prosecuted vehicular accidents with an injury. That all goes to whether this should have been a felony rather than a misdemeanor. And so it is terrible. But we got a misdemeanor. We're trying to figure out the restitution. So the fact that it was bad is bad, but it doesn't, isn't relevant to the restitution.
Well, Your Honor, I think it is, in the fact that she indicated she had a sprained shoulder and subsequent head injuries.
I
that she
agree
was
100%. That's why
taking-
this should have been an OUIL with a serious injury, but it
Your
isn't.
Honor, I don't mean to be disrespectful to the court. I'm just stating that these are important for the court to hear with respect to restitution. because additionally, her father, although he was allowed to work remotely, also had to provide daily living and assistance for her for those 2 days while she was in the initial injury phase. Now, with respect to that, they also had psychological injury. They're not claiming any compensation for that, although I can't imagine the
There's a version of this case that nobody saw, the one where a blood alcohol of 0.24, 3 times the legal limit, hitting a woman who was just trying to get home from work, resulted in real accountability. That version didn't happen. What happened instead was a felony charge reduced to a misdemeanor, a plea deal that left restitution completely unresolved, and then a separate hearing where a defense attorney spent hours arguing over whether a drunk driver should pay for the victim's prescription sunglasses and jumper cables. Michaela Shockley had a prior spinal fusion from a 2018 accident and was missing part of her intestines. She couldn't get herself out of the wreckage. Her airbags deployed. She missed 5 days of work with whiplash and a head injury. Her father, who couldn't get a loan because he was in the middle of bankruptcy, so I cashed in almost 3 years of saved vacation time. Vacation he had been banking for a summer trip, to buy his daughter a lesser Prius with more miles on it than the one that got totaled. The insurance company paid $3,900 for a car worth at least $14,000. And the defense fought the rest of it, item by item, to the end. The judge had heard enough. He told the courtroom openly that he teaches restitution law at New Judge School, that he has a, quote, sore point for under-prosecuted vehicular accidents with injuries, and that the defendant got a sweet benefit when the felony charges were dismissed. He awarded $4,243 in total, ironically close to what the prosecution had requested, and closed with a line that said everything. You're lucky she wasn't killed. Devin Allen Martin got a misdemeanor, a probation, and a restitution bill. Whether that math equals justice is a question you'll have to answer for yourself. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.